How's it going? We're here to talk about some dumb shit. We're gonna talk about YouTube comments, the best place to get information. And I have a partner in crime today. Would you like to introduce yourself?
Hi everybody, my name is OPT Lawyer, and I am apparently going to have a conniption or something over this.
Hopefully we might be able to set a couple people straight, and a couple people who will refuse to be set straight will be, identified for kind of the horse shit that who they are and what they're doing. So the two ones that we're gonna look at the OPT Lawyer showing up on Red's Rhetoric's channel in two occasions. One was reviewing letters as well as reviewing Kyle's motion that he put through to say that he wasn't properly served, and the other one was this case review, which is part 2, and that one is the one that just happened, which is talking about the response from the judge. I think everybody's on the same page now.
Yep.
Fantastic. So, as is stated here, Nothing about this stream counts as legal advice. Get yourself a lawyer worth a damn if you need legal assistance.
Yes, absolutely. Volume's very low, FYI.
I will turn us both up. Hopefully that is better. You guys let me know. I will turn it up again if necessary. Yes, and that obviously applies to this too. We're not talking about legal advice here. We're talking about dumb shit. None of this is going to be advice.
No, it's not.
So, first question listed in the comments here from Banther Tracks. Do all lawyers giggle like eight-year-olds?
I mean, when you're on a stream with Reds, yes.
Fair enough. I think that's a fair. Is our audio still low? All right, I'm cranking us a little more. Hopefully that's better. You let us know. Oh, OPT is high, I'm low. Okay, hold on. My things are probably adjusted from when I was in Steve's stream, so hopefully that should fix that real quick. Alright. Oh, now I'm peaking. Ooh, I overdid it. There we go. That should do it. Okay. Thank you for letting me know. Hopefully that is all adjusted. Okay. So yes, do all lawyers giggle like 8-year-old girls? And the answer is if they're in a stream with Reds, then yes. I think that's fair. I think that's fair. Any contentions in the chat, you let us know. No need to wait. Alien? No need to wait. Reds and OPT Lawyer obviously know how the judge will rule. What's the use of courts when we have smart guys as these?
Oh, gee, thanks.
Yeah, what a sweetheart.
So, I'm pretty sure during that stream I made it very clear that I wasn't sure how anything was going to come down, more along the lines of what I thought was going to happen.
Right. I also, if I'm not mistaken, there is a judgment that's already been ruled upon in this case.
There's a default, there is a default judgment. The issue now is trying to get Kyle to follow it.
Kyle seems to think that the legal system works the same way as a Twitter argument.
I mean, yeah.
Does it?
Sometimes, but not. It shouldn't, mostly.
It shouldn't, but sometimes it does.
I feel like sometimes it does, yeah.
Fair enough. What about this one? Do you think this is gonna go that way?
Oh, no.
This is an opinion, by the way.
Yeah. No. This judge here seems to be very professional about everything. And I'm not saying that it's anything other than just sometimes some weird thing happening. But no. The judge has made, in my opinion, the judge has made his stance at the moment very clear. So yeah.
So then we get into one that's a little bit more. It's got a little bit more to it. So this one's got a little bit of girth. I wanted to start us off with a little bit of fun. This one's got a bit of girth. Hey people, this is from Lulu63. Hey people, Rule 5, service and filing of pleadings and other papers. A. Service orders, subsequent pleadings, discovery papers, written motions, written notice, and other similar papers when required. Every other required by its terms to be served, every pleading subsequent to the original complaint, unless the court otherwise orders because of numerous defendants, every paper relating to the discovery required to be served upon party unless the court otherwise orders, every written motion other than one which may be heard ex parte, and every written notice, appearance, demand, offer of judgment, and similar paper shall be served upon each of the parties, but no service need be made on the parties in default for failure to appear, except that pleadings asserting new or additional claims for relief against them shall be served upon in a manner provided for the service of summons in Rule 4. Quote, last known address is found under Rule 5 and applies only to subsequent filings, pleadings, etc. There is no mention of last known address under Rule 4. That has to with the initial service of complaint. Rule 4 reads pretty straightforward, especially for formal legalese and all. Again, there may be other issues that can void Kyle's motion, but it's pretty clear a person must be served at the present address. Rule 5, service and filings of pleadings and other papers. A, service orders subsequent... They're repeating themselves. Go read Rule 4 and show where it says last known address is good enough, especially considering it is mentioned under Rule 5. Go just a bit further and read Rule 5. It is the only place last known address is mentioned, which means it is pointedly not mentioned in Rule 4. This is not hard. Subsequent means anything after the initial service. Whew, this person wrote a book. Well, this person copy-pasted a book.
Yeah, I was going to say, that's not written. That's copy-paste of the civil rules of procedure.
Right. So this seems to be... Now, I'm not sure if this person is meaning to conflate two things or if they're trying to clarify. I'm not 100% sure about the context of what they're actually trying to say. It sounds to me like we've got an issue of them saying last known address isn't good enough, but then they're also demonstrating the point of why it is good enough. Is that me? Is that just me? Maybe I'm misunderstanding what they're saying?
So what they're saying is that how they're reading the rule, I'm not saying this is how it is, I'm just saying what they're presenting is that it's Civil Rule Procedure 4, which is for the service of the initial complaint. Doesn't have anything in it about last known address. Civil Rule 5 is everything other than the initial. Basically, it's how you serve everything else, other motions, pleadings. We call the complaint, answer, and cross claim, counter claim, the initial documents and whatnot. But
gotcha. So anything else can be sent to the last known address, but they're saying that initial service can't be to last known address.
That's what they're saying. Yes. Now, I haven't researched North Carolina law to tell you if that's true or not. Steve's lawyer appears to believe it isn't, and I'm kind of going to go with somebody that has a license to practice, but that's just me.
You mean you're not going to listen to Lulu 63?
I mean, I know it's probably going to make them just feel really upset, but no, I'm just not offhand.
Sorry, Lulu 63. It does not seem like your shit's gonna fly here now, and I'm gonna go ahead and apologize if we misunderstood you. Our apologies. However, it seems like you may have gotten this a little bit backwards from what we can tell. Failed at Engineering for 5 says, love you, kissy face, and Ilya Mood sent us a happy fox dancing around with hearts. Yeah, thanks. Okay.
Not to mention the fact that Steve's lawyer didn't quote Civil Rule 5 in his opposition to Kyle's motion in the first.
Good point. That's true.
Because I just pulled it up and I'm looking at it here. Yeah, there's no Civil Rule 5. He didn't quote Rule 5 in any way. So I don't know why this person's quoting Rule 5. If
he, meaning Kyle didn't live there. It should have been sent back. Also, he has admitted knowledge of the lawsuit. He default judgment will continue on. Too late, you slimeball. Yes, it would have been sent back. It wouldn't have just been signed off by somebody and then gone. That's not how that works. Because by that logic, you'd be able to change your address not even change your address, just say you don't live there, get somebody else to sign for you, and then nobody would ever have to appear for anything.
Yeah, I mean, that's the thing of it. If you take what's happened here to the extreme, you get exactly that. The fact that, well, if somebody else signs for it, I could just say, oh, wait, I don't live there. I live over here. And then, I maybe, have a rental agreement, whatnot, or, even just make up papers, really, or whatever, there's an extreme there. And, I just don't. Anyway.
And yet, Mr. Know-It-All, referring to Steve, I assume, Kyle was improperly served by North Carolina law, therefore, who was wasting the court's time? I think it's who you're supporting, because yes, Kyle was served, but he wasn't served properly, and North Carolina has a whole lot against that. You might want to brush up on your legal skills, or at least know what you're talking about before you say who wasted the court's time.
I think this person's talking to me, actually.
Oh, maybe. What do you think?
Well, as I always come back with when people say anything like the first sentence, I think we'll call it there. Cole, where did this person get their law degree from? Because you don't have to even pass the bar. I'm just curious where somebody has, got their law degree from, so they can actually sit down and tell me that they've done the research and not just, taken somebody else's word for it without having actually looked at something.
So this is Chris Tucker. There's a little bit of an issue in here. Specifically, what is service for? Service is to let someone know they're being called to court, right?
Well, there's that, and then there's a due process issue. We want people to know they're being sued. Due process requires that you have notice of an action against you. Mm-hmm. So that's why, let's just hypothetically speaking, if somebody was not served properly, that's why the judgment, like a default judgment, would be considered void if they did not get proper service. I'm obviously not saying that's what happened here. I'm just saying in general.
If that was the case, yes.
Yeah, if service is improper, then a default judgment is void on its face, and the court should basically vacate it, and it has the power to do that.
Right.
And that's why, because it's due process concerns.
People have to know, right? Like, you can't expect somebody to show up for something that they're not aware of, obviously, right?
Right, exactly.
But then
because it's just not fair.
Right, yeah, exactly. But then the question becomes, did Kyle know whether or not he was served?
Oh, geez, Chess, I don't know. Do you might have some kind of idea if he had any idea if he was served or not?
I think maybe I might have a clip of Kyle saying that he was served, maybe? Do you think maybe that exists?
I don't know. Does it?
I don't know. Let's go to the next question.
Okay.
Twitter does not exist anymore because he used it as his own personal Twitter account. Why do you all want to skirmish through his personal messages with subscribers?
It's a business account.
Right? Is that not the most obvious thing on the planet? What?
I didn't even see Steve's reply down there. That was just my first. It's a business account. I'm sorry, when you use it for the brand, it's no longer your personal account. It belongs to the business, which now, according to this.
Oh, sorry, I got an internet hiccup. Did we lose him? Is that my end? Is
I'm
that
here.
Your end? Oh, okay. Sorry. No, you cut out on my end. Can you continue?
Oh,
what you're
sure.
saying?
I was just. Hold on. I was saying it's a business account, so it belongs. When you use it for the brand, it belongs to the business. I mean, and there's probably way more complicated about that. I'm not a business attorney, but if you're using it for the brand, it's part of the business. And Steve now technically has control of the business from that order, which means he should have all the assets, including the Twitter business account. I'm sorry if Kyle decided to use it as his personal account. It doesn't matter because it wasn't.
Oh, fair enough. I think that you run into a couple of issues, and I think one of those main issues is that listen, if he uses it, even if it's his personal one, even if it's completely not related to and never was related to the Non Sequitur show, if he used the handle Kyle Curtis at Non Sequitur show to create the account, it belongs to Steve. Because it's all of its assets, which includes anything that Kyle made using that handle. All of it. My God. Why is this not... I don't think this person realizes... This is this Chris person again. I don't think this person realizes that the Non Sequitur show Twitter, he changed the handle. And in doing so... fraudulently has a bunch of followers that are actually followers of Non Sequitur show, just following his random shit.
Right.
For all accounts, he stole those followers from Steve. What is Steve's account? And the thing is he'll still have to give that account back because it's still under that same email, which is a Non Sequitur show email account. Mm-hmm. Oh, and to the second half of that, why do y'all want to skirmish through his personal message with subscribers? Because that shit's gonna be juicy as hell. The hell if I don't want to see that shit. I'm not gonna lie to you.
Well, again, it's part. Chris literally says it right there with subscribers, aka people who subscribed to the Non Sequitur channel business account.
Yeah. I don't know if there's much more to do, but yeah, I want to read those. I absolutely want to read through Kyle's personal messages that he was dumb enough to put on a business account. Do you get in trouble at a workplace if you use your workplace to converse with somebody about porn? Of course you do, because it's a business.
Yeah, if you're gonna do that, don't use your business account.
Don't use your business account, dumbass. Oh my God, do you think Kyle, like when Non Sequitur was still going on, Kyle was going off about his Grindr profile. Do you think he made his Grindr profile with the Non Sequitur show email? Because that would mean we would get all of those.
I don't think I wanted it. Like, you would want to see it. Well, maybe you would. I don't know, but I wouldn't want to see any of those.
I feel attacked.
That's okay. Sorry.
I'm just kidding.
I know.
Oh, no. Yeah, I'm not sure if I would want to see that either, but that might be a thing that technically belongs to Steve now. Okay. Moving on. Truth Seeker. No, that's this name is definitely going to be on point with this.
I seem to find that people with the name Truth in their handle don't seem to like it very
well. Well, let's see. No judge a book by its cover. Let's see. Truth Seeker.
That's true.
Even if Kyle had actual and sufficient notice, if he was not properly served, the court has no jurisdiction over him. You need to prove you have jurisdiction. Notice is only one part and is insufficient in itself.
Which is why they have the certified mailing and his address, at least where he represented he had lived last time, to anybody else.
It's almost like Kyle is responsible for Kyle in updating his address, and it's not the court's job to search him down unless he doesn't do that and it isn't signed for. Then it is the lawyer's job to search him down.
Here's the other thing. Like, I actually don't know that one, but here's the other thing with this guy's comment here that I'm just thinking. Steve doesn't have to prove he's got jurisdiction at this point. Kyle's the one that has to prove service was improper. Like, the onus is now on him at this point, so...
Right, yeah, they've got burden of proof swapped. They're thinking burden of proof. So essentially, because service is assumed proper, you have to demonstrate that it's not. It's the burden of proof is on the person who's trying to say it wasn't proper. Now, it sounds to me like they're trying to use sort of like internet argumentation styles to say that, well, no, Steve's making the claim by saying that it was proper service, then he has the burden of proof, right, which is not how it works in court.
Well, so actually, to expand that out more, Steve had the burden of proof to show service was proper when he served the complaint. The court accepted that service was proper, and it's now on Kyle to show, wait, no, it wasn't.
Right, and that is
what we're at this point, yeah.
Yeah, and that's what the court asked for. So Kyle initially said his thing saying he wasn't properly served. Steve's lawyer counterclaimed saying, no, it was properly served and here's why, and then it's on Kyle to be like, to demonstrate that, even though he probably should have demonstrated that in his first case, which he did not. He just made the claim.
Yeah.
And then he never responded to Steve's lawyer. Surprise, surprise.
Mm-hmm.
Okay. So, next one. Also Truth Seeker. Explain to me how you can read that rule and think that it is okay to serve at a prior or last known or regular address. It clearly says, quote, leaving copies at the defendant's dwelling, ... To me, that means where he lives now, question mark. And if you read high court commentaries on the rule, they all say it must be where he lives now. OPT, quote, they're quoting you. There is clear evidence he was using that at some point, end quote. Yes, at some point he used that address. It does not mean it is his dwelling at the time of service, ... Is there any North Carolina statute that says you must correct your address when you see someone else using the wrong address? Question mark? I don't think so. But please give that rule. Or is there a statute that says if you see someone using the wrong address that you consent to that address if you do not speak up? I don't think so. This person has lost the plot.
Yeah, well, and plus he clearly has a license to practice because, he's telling us how the law works.
Obviously. Okay, so I think the first problem that I'm going to see in here is that it is your responsibility to leave a forwarding address.
Yeah, because otherwise you'd be looked at as dodging service.
Right.
Yeah, I mean, again, I get back to the extreme of, like, what's happened here. Like, if this is not proper service, then it's very easy for somebody to dodge service for a very long period of time until now your suit's, like, not commenced properly and you're out of time and all this other stuff.
Yeah, it's reasonable to have protections in place for people not getting the information. Like, that's totally reasonable. That should be the case. However, it is your responsibility, like, when you do taxes or when you move, that not only do you update your address for government documents, but you also leave a forwarding address with your previous people that are moving into your house, or with your previous landlord, or whatever the case may be. You leave a forwarding address. It's as your responsibility. Was the government supposed to hold your hand?
Right.
Because then you would just be able to dodge it forever. You would just forever be able to keep moving. Because by the time they found you again, your lease is up and you go to the next place. And never leave a forwarding address.
Yeah, pretty much. Like, it's just... I just look at things like this and just shrug, honestly, most of the time. Because it's like, you don't... Person, as you said, lost the plot. They don't quite grasp everything that's being said or talked about. They don't quite grasp like what the issue really is here. I mean, he okay. The issue is he claims Kyle wasn't served properly. Great, okay, cool. But have you read the case law? Because guess what? Everybody here keeps quoting rules, which is great and all, but there's also this little thing that we call case law that also affects every single thing out there.
Oh, gotcha. So, right, okay. So let me make sure I've got this through my thick skull. The original papers that I was served.
Yeah, you'd think that would be a...
I don't know what more you need at that point. Well, they weren't proper service. Did he know? Is it reasonable for him to respond? Has he been responding? Yes, and yes. So... I don't get it.
Yeah, I don't know.
Okay, this guy is probably my... We got a comment from Mike that says, it's like saying, quote, you can't give me a ticket for blowing the red light because I didn't see it, end quote. Why didn't you see it? Because my eyes were closed. Kinda, yeah. I didn't know I was going to court because I didn't open my mail that I got.
Right, exactly.
Mr. Wheezy 312 is probably like the worst in this comment thread. They're hilarious. Okay. This video is unbearable. Kyle has done a bunch of dumb shit, but that doesn't mean his legal arguments don't hold water. This incorrect serving was a blunder on Steve's part. Why is that so hard to say? Reds, why did your lawyer friend not watch Kyle's vid? It does actually contain Steve saying he served Kyle's old address. Why did you not play it for him? My favorite how is... I hate YouTube comments. Grammar, motherfuckers.
Right.
My favorite... How's he gonna say the vid is too short and out of context? You just admitted to not watching. At least keep your criticism from contradicting in your bizarre hate Kyle fever. Okay. Kyle has done a bunch of dumb shit. I agree. That doesn't mean his legal arguments don't hold water. Correct. But it does make us suspicious that they probably don't.
Right, yeah. It's right. Just because Kyle has done a bunch of dumb stuff doesn't mean anything he says is wrong. It's just that he's wrong because he's wrong.
He's dumb because he does a bunch of dumb shit, not he does a bunch of dumb shit, therefore he's wrong. They've got it backwards. It's right. This is part of the dumb shit that he's been doing, but we're not using him being a dumb shit to justify us saying he's dumb shit or that he's wrong.
Right.
This incorrect serving was a blunder on Steve's part. No, Steve did not serve Kyle. Steve's lawyer served Kyle. It's not like Steve walked up to Kyle's house, flew from California to North Carolina, walked up to fucking Kyle's old house, went, "Hi, Mrs. Curtis, is Kyle home? I have a piece of paper for him. Would you like some Girl Scout cookies?" Alright, so no, it wasn't incorrect on Steve's part. So that is difficult to say because it's stupid and incorrect.
Right.
Reds, why did your lawyer friend not watch the video? Because not everybody's got time to listen to Kyle goddamn blathering all the fucking time, and you don't need to watch the video to address the question.
Right.
It's almost like you don't have to watch every single piece of everybody's content to be able to address an argument. Right?
Right, yeah, you'd think.
You'd think. Provided you, like, and if you got something wrong about what they actually said, then you can correct yourself. Then you can find that out. That's fine. It's not like anybody presented the information to you in any kind of incorrect manner.
And I hate to say it this way, and Steve, don't be offended, but I don't really care what Steve said because he didn't do it. It was his lawyer.
Right. Yeah, it was his lawyer anyway.
Right, exactly. His lawyer is the person who served, or at least, who sent the complaint to the Kyle's address at the time. I don't care what Steve said on a random video someplace else.
I also like this bit one. Reds, why did your lawyer friend not watch Kyle's vid? It does actually contain Steve saying he served Kyle's old address. Notice that says old address, not wrong address. I feel like they kind of broke down their own argument, like, right out the gate. Why did you not play it for him? Dumb question. My favorite, how is he gonna say the vid is too short and out of context? You just admitted to not watching it. At least keep your criticism from contradicting in your bizarre... There's no contradiction going on here.
Yeah, I don't know what he's talking about.
This word does not mean what you think it means. This isn't a contradiction. Saying, like, listen, I didn't watch the video, but this is the context and this is what he's talking about. Is this applicable, yes or no?
Right.
Right, and you can answer that question without it being out of context. If it was out of context, or why isn't this person bringing up what exactly the issue is? Because he's not. He's not actually demonstrating anything. The closest you get to demonstrating anything in this comment is Steve saying that he served Kyle's old address. Yeah, and that's a problem because...
Don't know.
Like, again, Steve wasn't the one who served him. Hey, look, there's Steve saying, I didn't serve Kyle, genius.
Right, there you go.
That's part of the problem, Steve. You're out of state and can't ensure it's done properly besides your lawyer. Besides your lawyer?
Wait, what? Wait. I'm sorry. No.
Yo,
no.
YouTube comments, man.
No.
This is the dumb
No. No. Okay. So,
Mr. Wheezy said his shtick. Steve said, I didn't serve Kyle, genius. Mr. Wheezy 312, the brilliant mind that is Mr. Wheezy 312, says, that is part of the problem, Steve. You are out of state and can't ensure it's done properly besides your lawyer. Did he work for you and this is your case, so ultimately the buck stops with you?
No! No, that's not how that works! Oh, God! Okay, so, there's so much to unpack with that stupid little statement.
Okay, let's go one bit at a time. This is part of the problem, Steve. You are out of state and can't ensure it's done properly.
Okay, so, again, that's why you hire a attorney in North Carolina, which Steve did. This is why you do things like this. Is why you hire an attorney out of state. Yes, shockingly, people hire attorneys out of state all the time to do stuff in their state.
Does this guy think that Steve's lawyer is a California lawyer?
I don't know.
I finished my beer. God damn it.
I'm only drinking water, for crying out loud. I needed something stronger.
Okay. And, okay, you're out of state and can't ensure it's done properly, besides your lawyer.
And that's why you hired him. Thanks. You very much. You've proven our point. Good job.
So this whole first half of this comment, meaningless. Cool. Did he work for you and this is your case, so ultimately the buck stops for you? Did he works for you? Fuck.
Assuming I can understand what he's actually trying to put into words right there, the answer is yes, that lawyer does in fact work for Steve. Because Steve is paying him money.
So his argument is, therefore, if the lawyer served it wrong, then it's Steve's fault. Fuck you, Steve. Everything's your fault.
And I know Steve has hired like a firm in actuality because he had a lawyer change for reasons and whatnot. I just keep saying an attorney because it's easier.
Yeah, that's totally fair.
Yeah, and so the buck stops with you as the client. Okay, so theoretically speaking, the client is the one who is control of their case. If they say, you know what, I want this dismissed, I don't want to deal with it anymore, the lawyer has every obligation in the world to do exactly what he says. Now, if the client says, the attorney comes to the client and says, hey, the defendant's offered us this settlement. The plaintiff or the client has absolutely all the rights in the world to say yes or no. And whichever the client says, that's what the lawyer has to go with. Now, that doesn't mean that if the lawyer has done something wrong, it's Steve's fault. Again, not saying anything wrong happened here, but if the lawyer did something wrong, that doesn't mean it ends with Steve, it ends with the lawyer. And then we get into disciplinary issues and whatnot, or just fixing it. Just because a lawyer makes a mistake doesn't mean that, one, it's malpractice, or two, it's unfixable.
Right. This is super bizarre for a couple of reasons. Because, so he's saying that he's kind of almost suggesting, I don't think he's actually bright enough to be trying to suggest this, but it seems like he's trying to suggest that Steve paid a lawyer to improperly serve Kyle on purpose.
Right?
He's like, hey lawyer, make sure you send it to this address because it's the wrong one, because it's his old address. And then the lawyer went, okay. Which probably a lawyer would not be okay to do.
It's the people that don't understand, like, the process from Go that really get to me. And assert that they, like, this person is, and I mean, I wasn't going to do anything like this, but this person really is, like, what's the phrase I'm thinking of? They are, like, passionately ignorant. That's it.
Passionately ignorant? Oh, I'm keeping that. I like that. That's a good one.
I mean, because they are passionate, because they are saying, like this is true, and they don't know.
Oh my, yeah, no, you're right. That's a really good point. That's a really good point. Yeah, they're just so happy to be incorrect.
Right. Or just at this point, it's not even incorrect. You just don't know. I mean, it's wrong. You know, you don't know the first point, and you've lost it already. And yet, it's like that Back to the Future 2 or in the alternate timeline kind of thing. Like, you're just gone, and you've been gone since the start.
Oh, when they all disappear?
No, like like when it's the second one, when they go off into the tangent 1985 because Biff went back in time and created an alternate timeline. Yeah.
Love those movies. Rivet said, I don't know, hopefully I'm pronouncing your name right, I apologize. Looks like the Kyle Gremlins. The Kyle Gremlins keep getting hung up on colloquial definitions not legal. Very big difference. Example, short-barreled rifle, long-barreled with a short stock counts. Yeah.
That's good. There you go. Yeah. Yeah, so as I was saying, like, yes, there are the civil rules of procedure, and then there's how they're both interpreted and applied, which you have to go to case law for, which Steve's lawyer cited in his opposition, and Kyle did not really cite any on-point case law because all of it was out of state, if I remember correctly, including a case from Ohio, which I'm like, that has nothing to do with your stupid case. Chess, I can't hear you any longer.
Oh, sorry, I muted myself. I take it back. I regret everything. Charles Starbucks said, oh no, someone having very strong opinions on subjects they know absolutely nothing about. That never happens.
Right.
So this gets better, because Mr. Wheezy 312 keeps going. Steve said, you're really a moron. Lawyer is paid to do it properly.
As we just said.
Uh-huh. Okay, then why is there a problem? There isn't.
I'm done. That's it. Like,
oh, come on. It. We're not even halfway through the first one.
That's it. I'm talking with him. Like, this is it. That's it. Why is there a problem? There's not. Good job. Congrats. You got it. Good.
Congratulations.
Bye.
You got it right.
That's it. See you, bye.
If something was done properly, orders of dismissal aren't filed. No!
Right, because guess what? That one hasn't been filed yet! At all!
Kyle didn't file an order, he filed a motion.
Not to mention, it wasn't even really. I mean, there was a motion to dismiss in there. I don't even remember at this point. But regardless, the only thing that would happen here would be vacating the default judgment, and it wouldn't dismiss the entire case outright.
Congratulations, Mr. Wheezy. You're correct the first time. Then why is there a problem? There isn't. If something was done properly, orders of dismissal aren't filed. Correct!
Right, correct! Good job! Gold star on that one.
When one has a good argument, ad homs aren't resorted to. That's not an ad hom.
And so, I'm assuming at this point he's talking about some point in the video, or either me or Red's probably made some snide comment about Kyle and whatnot. And you know what? Here's the thing. Yes, ad homs are bad, but that wasn't what we were doing at that point. We already pretty much debunked your entire thing, so at this point we're just making...
Right. I think they're trying to say that what Steve is saying is an ad hom.
Okay.
What Steve says is, you really are a moron. Lawyer is paid to do it properly. He called you stupid and addressed your point. He didn't say your point is invalid because you're stupid.
Right, yeah, exactly.
Which is kind of what you tried to say we were doing up here also. Kyle's done a bunch of dumb shit, but that doesn't mean his legal arguments don't hold water. Correct! His legal arguments don't hold water, therefore he is a dumb shit.
Nice.
There you go. Got it? You got it?
Yeah, exactly.
We got it. Okay.
That's the logic proof right there. Good job.
We got it backwards. Last time I was a total moron was when I took you seriously. That was pretty stupid. I'll admit you got me there. See, I can be a dick too, so why don't we act polite? Polite, be adults, maybe. Maybe if you want to be taken seriously, could you please not only know a damn thing about what you're talking about, but also use any kind of proper grammar? I'm not even talking about commas and periods. I'm talking about sentence structure at this point.
You know, at this point, I'm just going to say I'm pretty sure Mr. Weezy 321's first language is not English. I mean, because if it is,
so.
Because if it is, I've lost all faith in any kind of system we have in this country. Yeah, I have to assume at this point that English is not this person's first language, and I don't mean that as a diss. I'm just saying as a opinion, because otherwise, this is not.
Yeah. Jerry Penna then says at Mr. Wheezy, but Steve is great at keeping friends. Just ask him. That's an ad hom. You didn't address the point. You just said Steve's bad at keeping friends. You addressed nothing. Well, it's not quite an ad hom, but it's closer. This is more accurate.
Right.
But what if the lawyer was paid to do it properly and then didn't do it properly? That's still not Steve's fault.
Right. You would have...
Alien...
You would have, like, actual an actionable complaint against your attorney if they did something wrong that ended up screwing your case over entirely. Again, hypothetically speaking, had this attorney not only done, like, service improperly, but done something to the point of barring Steve from ever actually filing this suit again, Steve could then turn around and sue this attorney for malpractice, and at that point, you get the fun, what we call case inside of a case thing, because Steve would then have to prove that, one, he could recover from Kyle, and two, the lawyer screwed up so much that he can no longer recover from Kyle. So now he gets to recover from the attorney.
Right. So it's a matter of, like, that's actually not a terrible question. What if the lawyer was paid to do it properly and then didn't do it properly? However, we know this person is being a piece of, like just not actually asking that question. He's saying, but what if the lawyer was paid, right? He's saying that if as if it's true, because as we saw earlier, they're already commenting this shit. So they're making the assumption that it was. Right. So, Mr. Wheezy responds to this, Gulio? Italian, whatever, responds to them with, "Nonsense lawyers have never ever been known to screw up on the legal technicalities." Nonsense
I'm sorry.
lawyers?
Well, no, I think that. So I think there's supposed to be a comma there, or a period. Nonsense. Period. Lawyers have never been, and that's how I'm reading it.
Oh, okay. All right.
So
Thank you.
So here's the thing. I mean, I'll straight up admit that lawyers make mistakes all the time. I mean, as my father once said, it's called the practice of law for a reason. So, here's the thing of it, though. One, not saying that happened here in any way, shape, or form. And two, so what? We're human. We all make mistakes.
Mike in the chat says, he said no, therefore Steve loses his court case.
Right? Yes, that's how this works entirely. Oh, he came in and said no, sorry, that's it. Nope.
I think I may have scared McBoomerang. Okay, I like that. Steve McBoomerang. I think I may have scared Steve McBoomerang away. He can't handle the amount of self-own he did to himself. Here, well, drunk and mad. At least I hope he was drunk. Otherwise, he thought that was smart. Mr. Weasley, can we please look at your previous comments up here?
I have no idea what the rest of that means.
This is, like, so close to, like, pot calling the kettle black in that case, if he was correct. If he was correct about Steve, this is 100% you've completely been like, you don't know what you're talking about, therefore you shouldn't be talking about this.
Right.
But this person is Mr. Wheezy312 in a YouTube comment section. That's an ad hom. That is an ad hom, because I'm dismissing him because of his name on it and because he's on a YouTube comment.
I don't know. I think YouTube comments, I think, just transcend the ad hominem in my fallacy, right?
You think? All right, I'm convinced. I'm convinced Anthony Riley is Kyle's lawyer or legal advisor.
I have said before, I don't know who he's getting advice from, but whoever it is, he needs to talk to that person.
No credible attorney at law would let you go online and discuss an ongoing case. This would prejudge the case. This would prejudice the case, yeah.
Prejudice the case.
Prejudice the case? Prejudice.
Yeah.
Prejudice. I'm scrolled up too high. Sorry. It should lead to the case being thrown out. Why would two people who aren't Steve or Kyle talking about this shit that is a public document on the internet throw out a case that has nothing to do with them?
Yeah, okay, so here's the thing. Number one, let's pretend for a moment Steve was on that stream. Talking about a case publicly doesn't make it get dismissed. I have absolutely no idea where that even comes from. And two, yes, yes, attorneys for the most part don't want you out there talking publicly about your case. But if you do, I mean, Steve hasn't done anything that harms his case. He's just talked about mostly just stuff that's been in the filings anyway. If you're talking about publicly available information, it doesn't matter. And yeah, as someone in the chat just aptly says, there's been no gag order, so guess what? You can talk about whatever the living crap you want to.
Well, and nobody's saying that he's been advised one way or another to talk about it or to not talk about it. Steve's not an idiot. He talks to his lawyer, which means that he's going to question what he can and cannot talk about, because this is a public case that involves a lot of people. And I'm going to repeat that. Involves a lot of people. Steve and Kyle are not the only people involved in this case. They're the only ones actively that are active in court, but they're not the only ones active in the case in knowing what's going on or knowing about what the future will hold or have a stake in this, let's say. Boole, me, Reds, every single one of the Non Sequitur show fans who contributed to that show in any way, shape, or form, including but not limited to volunteering, modding, art, music, commenting, viewing, donating, all are related to what the hell is going on. All of them have every right to talk about what's going on, and all of them have every right to know about what's going on.
Yep. Yeah, absolutely. And again, it's you can talk about whatever the heck you want to in a public forum, period, straight up. And unless the judge issues a gag order, which hasn't happened in this case and has no reason to happen. Like the only thing like that the court like a business court like this would ever have to worry about is trade secrets becoming public. And a lot of times when cases involve that, those documents are filed under seal because, again, you don't want to necessarily release trade secrets. Understandably, there's no trade secrets here.
Boole makes a good point. He says, oh, that's why OJ got off, because it was discussed publicly?
Exactly.
Right. Makes no sense. So thank you, Fortunate Son, for your garbage comment that makes no sense. Oh god, no, Mr. Wheezy's back.
I really do like the comment directly under Fortunate Son. I can't.
The Mandalorian? Okay, yeah. It says, you think that the judge is going to throw out a civil case based on the ramblings of a plumber and a criminal defense lawyer online on documents that are public record?
Exactly. Yeah. Yeah, like, I'm sorry. If that ever happened,
Ninja Monkey Prime, how would a judge not allow people to discuss documents that are made available to the public? Are you not aware of what it means that documents are made available to the public?
Yeah, I mean, so it is true that not everyone necessarily knows where to get said documents. I know to look on every single clerk of court's website because a lot of them have this stuff online, but they're public. Anything filed in a court is technically public. You can go to the court, look at any file that isn't sealed.
Right. And there's no trade secrets involved with NonSeq, or at least not as far as I'm aware.
Well, this isn't a trade secrets case. This is straight up you converted the channel to your own thing with axing me out of the 50-50 agreement we had.
Right. So it's safe to say that Fortunate Son comment has absolutely zero standing.
Yeah.
Cool. Mr. Wheezy 312 decides to throw in their 2 cents. Mr. Wheezy is slowly becoming my favorite. Seriously, people, the comments no attorney at law has ever told a client, quote, sure, go talk about your case to everyone and do it preferable on videos posted to the internet, end quote. LOL, it's the worst legal advice ever. They are afraid you will contradict yourself or harm your case, which he seems to have done here. Yes, judge can give gag order. No, I don't think it will happen here, but judges absolutely have the right to do damn near anything to ensure a fair trial.
I mean, okay, yes, that's correct. Judges have a lot of power to make sure trials are fair. Absolutely, there are rules that need to be followed for that. Yes, judges can do a lot of things to make sure trials are fair. I don't really have any clue how talking about things publicly would make something unfair except to the person who did it, which he even says here. It's just kind of weird. His comment, while a lot of correctness in it, is completely wrong.
No attorney at law has ever told a client, quote, sure, go talk about your case to everyone and do it preferable on videos posted to the internet. Okay, first off, that's really, really oddly specific. Right. So it is possible that no attorney has ever said that. However, it is very possible that an attorney said, yeah, sure, no, it's fine to talk about your case. Yeah. Just don't slander the person you're talking to or that you're at court with.
What this person is clearly, like, not understanding properly is, did Steve's lawyer advise him to go talk about the case publicly? No. But did Steve's lawyer tell him not to? Steve says no. Steve says his lawyer knows exactly what he's doing. And his lawyer said, yes, that's fine for you to do. That's not him giving legal advice. That's him saying that's him basically saying that's not going to hurt your case, so do whatever you want.
Right. And as long as it's not hurting your case, it's just no...
Yes.
This falls under you're technically correct because it's very likely that no lawyer has ever said this exact phrase.
Right, yes, exactly.
Good job. It's the worst legal advice ever. They are afraid you will contradict yourself or harm your case, which seems to have been done here. Well, no, because that's not what was done. Because we're still talking about the proper service or not. Steve saying that it was served to a previous address is not improper service. Remember when Mr. Wheezy asked, so what's the problem? We said there isn't one?
Right, yeah, exactly.
Thanks! Steve actually responded, "You're a complete idiot. Reds isn't their client. He can damn well talk about anything he wants. Gag order? Are you fucking for real?" Yeah, no, the thing is in this video, it's you and Reds talking about this. This is not Steve anyway. So the whole point is completely moot.
Okay, I was reading the next comment below that, and I realized it was a joke, so, okay.
Oh, Scuba Steve? Yeah, Scuba Steve has a pretty good... Hey, guys, seriously, Steve McRae owes Kyle money. In fact, the judge owes Kyle money, too. Kyle's doing 95% of the lawsuit work here. Everything with Kyle's name on it is copyrighted. You guys don't get it! I'm surprised he's not using the Chewbacca defense. I can't do a Chewbacca noise. I wish I could. Oh. This person said everything is everything, said keyword equals copyright. No one will pay Kyle what they owe him. Poor guy who has to wear $13 suits. Oh, God. Okay. Fortunate Son is back. Are you using the royal we as in me and Steve we? Dude, figure out context. It's almost like non sequitur matters to more than one person. In this case, matters to more than one person, and a lot of us deal with Steve and work with Steve in the background. And so in that case, yeah, we mean, when I say, hey, our lawyer, I'm referring to Steve's lawyer specifically. I'm just referring to it in that way because I'm talking about non sequitur, not just Steve, because it's almost like non sequitur belongs to Steve and to all of us. It's right? Dumb. This person's saying there's going to be a GoFundMe. I guess this person doesn't actually know who, and like hasn't been paying attention about who is actually funding Steve's case. Yeah. Special thanks to Ruhif, by the way. There's not going to be a GoFundMe about this. It's completely not necessary.
Yeah.
Once a judge... Geez, Fortunate Son was busy. Yeah. Once a judge sees that both of these have came into court with, quote, dirty hands, it will be dismissed. Please be honest or GTFO. And never darken my door again.
Okay,
what
so that's
the
also
fuck
not
are
how
you
that
talking
works.
about?
So, yes, just because people come into a situation with quote-unquote unclean hands doesn't necessarily mean that your case just gets thrown out. It does weigh necessarily on some things like damages and amounts and things along those lines, but that's what comparable negligence is for, and depending on what state North Carolina is, not that any of that matters. This guy's comment is just completely irrelevant.
It's asinine. So, I think that, let me use an extreme example. If Kyle shot Steve's sister, and Steve shot Kyle's sister in retaliation, it would be two separate cases.
Yes, that would be two completely separate murder cases.
Right, so Kyle can be guilty, and Steve could be guilty. They don't cancel each other out, and neither are guilty, so it gets thrown out. There's still two dead people.
Right, yes, exactly.
This makes no sense. Okay, I'm glad it's not just me. Okay. Please be honest or get the fuck out. Bitch, you're on somebody else's channel. Nobody's knocking at your door at all.
Yeah, as Charles in the chat said, quit forcing videos on Fortunate Son, dang it.
How could you know?
Right.
Once the judge sees that both of these have come to court, judgment has already been rendered. Please catch up. Good point. Wrong. This is a default judgment, not a final judgment. I feel like you don't know what that means.
Okay. So, yes, he's correct in that it is not a final judgment. That is because the court is still attempting to figure out how much Kyle owes Steve, monetarily speaking and whatnot. There's been a judgment order, as in Kyle's supposed to turn all this crap over and whatnot. But yes, there isn't a final judgment because the case isn't over yet because we're still working out damages at the moment. So yes, you're correct. Good job, fortunate son. Unfortunately, I feel like you got that wrong. Unfortunately, I feel like you got that right despite yourself, but whatever.
I would almost say that this should be phrased differently. They should be talking about a partial judgment, not a default judgment, because the fact that it was default is not relevant. It's that it's a partial judgment.
Yes.
Cool. Still a dumbass. Are you jumping the gun here, sir? Let the law take its course. You're literally spending this entire time bitching. Take your own advice.
Exactly.
See, default judgment. That phrase does not mean what you think it means. Thank you, The Mandalorian. You've actually got that correct. Good job.
I like this. I like The Mandalorian. That person's nice.
I hope they come over to this channel sometime, maybe, and see. I don't think they've been here yet. I like this comment, Harry M. I've seen Harry M around before. Lawyer, at the bottom, so you. At the bottom of the page, Reds, scrolls down to the bottom of the document. God damn it.
I remember that. I'm like, oh, it's at the bottom of the page there. He just goes all the way to no, the bottom of the... Yeah, that one.
Oh, Lord. Don't most states require you officially change your address within 30 days of moving? How can he complain it was a wrong address when he's not following state regulations?
I don't know what North Carolina's is. I can tell you that in Ohio, I believe when you move, you're supposed to update your driver's license within 30 days or maybe even less. But I can't speak for North Carolina.
Right. So it's a matter of like what we were talking about before. Yes, you are responsible for updating your address and or leaving a forwarding address. So no, Kyle can't complain. His complaint is based upon himself and no one else. He's complaining about past him, essentially. Well, right. Past me didn't update it, therefore I didn't get it. Well, that's still your problem. This is a you problem.
Right.
Where did we go? I lost it. Where was the next one? I like this one. This one's my favorite comment on this entire thing, and is not related to anything. Angel of Attack said, I couldn't listen to this cringe fest. Reds has a brilliant mind for science and argument, etc., but the sense of humor of a middle school boy hopped up on Mountain Dew.
Yeah, he's not wrong. Yeah. But I like Reds. So it's a fun time. Like the 2 streams we've done, those were fun. So yeah. But no, I can't say he's wrong on that.
Yeah, no, totally a fair assessment, and, you know, some people like it, some people don't, also fair. I just think it's one of those rare insults that I was just like, that's creative. I like creative insults.
Yeah.
Looks like a lot of places have 10 days. New York, is PA Pennsylvania?
Yes, that'd be Pennsylvania.
Hey! Also 10 days, apparently. Look at me go. It's weird that OPT lawyers in quotes, of course, wouldn't see an issue with proper service, but at least Steve outsourced to his sidekick. He may have learned to finally shut up. No, I don't think Steve will ever learn that. Let's be straight. Let's be honest here. Steve's never gonna shut up.
Yeah, I have to tell you this, Parson K, but the lawyer is real. I have a license to practice, and I have a bar card in my wallet, which I'm not going to show you. But yeah, no, I'm licensed. So yeah, sorry.
I think Soapy Coon's got this right. What issue is there with proper service? And believe me, as long as Steve is right about this case, he's not going to shut up. And then somebody jumped in here, Jigsaw jumped in here and said, what's the issue with proper service? And the lawyer is certified.
Thank you. Yes.
Oh, Lord. Oh, God, Mr. Wheezy's back. Cool.
Oh, my living... What the heck?
Okay.
That is long.
Yeah, no, I'll read quick. Soapy Coon. Doesn't matter that you think he is right, he still needs to shut up, which we already went over was not the case. Doubly so if he is right. That means he may have just killed an otherwise winning case. Speaking about an ongoing legal matter is 99.9% of the time a terrible and case-destroying idea. That would be a lot. That would be any case discussed in the media.
Yeah, that's definitely not the case.
Basically, unless the client is doing an interview with the media. Oh, the media is an exception. Sorry.
Oh, okay. Oh, yeah.
To help their own case with more publicity, has their lawyer sitting next to them who is vetting questions and especially vetting the answers the client gives. I would have to see evidence that that is always how it's handled in the media, because as far as I'm aware, absolutely not. Nothing should have been said at all. Okay, I feel like this person is completely, like, they're so close to the reason why Steve is talking about this all of the time, but just misses it.
Yeah.
To help their own case more with publicity and has their lawyer's consent. The things that Steve is doing and has.
I don't know many cases that are helped by having more publicity put on them. I know they exist, I just don't know many.
That's fair. The fact a dismissal has been filed with the court speaks volumes about why lawyers usually are strict about their clients staying quiet.
No, it hasn't! Where is he even getting this?
Oh no. He's talking about the motion. The court didn't file anything about this. Kyle posted some random shit about it.
And this is what I was talking about, but about missing the point from the start. It's like, just because Kyle files a motion to vacate the order doesn't mean it just happens. People file motions all the time that get denied. It happens a lot. Like, I don't, like, the fact of the matter is, just because Kyle shows up and says, well, he didn't serve my proper address, doesn't mean the court buys it.
This seems like imagine if that happened in, criminal court.
Oh, God.
Could you imagine, if you just filed a counter motion to say, no, I didn't do it, then it just threw out the case?
Yeah, exactly. He says he didn't do it. Well, sorry.
Sorry,
Mr.
guess he didn't do it.
That's it. Yeah.
Why pay a lawyer? So this actually also implies that the lawyer purposefully sent it to the wrong address. The fact that a dismissal has been filed with the court speaks volumes about why lawyers are usually strict about their clients staying quiet. That seems to imply that the lawyer would have told Steve not to say that it went to the previous last known address.
Right.
Which would be malpractice.
If the lawyer purposely sent the service to a place he knew the defendant wasn't, and knew that he was doing service improperly, that would have problems, yes. But that's not what happened here in any way, shape, or form.
And as if that wouldn't put a lawyer's reputation and lose your license kind of shit.
I mean, so that kind of thing, that's not even really this would just be a malpractice suit. As we always say, malpractice.
So he would get sued. So if the lawyer did this and then Steve said it and then it came back and because Steve said it, everybody found out that it was improper, then Steve would be suing it wouldn't even necessarily throw out the case entirely. They would just have to start the case again, or not even necessarily because Kyle's been responding. But he would then be suing the firm.
Right, because I think the major point is getting missed here, that even if service was improper, let's just pretend for a moment, even if service was improper, the only thing that happens is the default judgment gets vacated and we start the case from square one at the discovery phase. Right. That's it.
Gotcha. Why pay a lawyer so you can ruin his case with a stupid YouTube video made for free when all Kyle has to do is last minute swoop in with maximum effect and little cost? There is no swooping in. The judgment has already been done.
It's again, this person has assumed Kyle's victory in this motion. That's what this is.
Right.
Either he's assumed it or he believes it's already happened.
Right. Steve screwed the pooch here by admitting he had the papers, he had the serving papers sent to an old address regardless of the merits of the case technicalities. But you're arguing a technicality, and even an incorrect technicality, and again you're saying that Steve is the one who served the papers, and he was not. because he was not the one, because Steve's not an idiot and he hired a lawyer because Kyle's too stupid to do so.
Exactly.
Are still court orders and are to be treated as such, or else they will destroy the case. No, skipping that. We're skipping that. We went over it. Yeah. Worse, even if he gets to refile his lawsuit, if it was improper service on behalf of Steve's lawyer, it's not an if. He will get to refile. This is not an if.
It's not even a refile. No. It's not even a refile.
Yeah, it wouldn't even go that far.
It just the judgment, again, the default judgment would get vacated. The suit isn't just dismissed when that happens. It just goes back to the point of before the judgment.
This is so dumb. His lawsuit now thag? His lawsuit now something. Kyle may now make a defense. He could have made a defense the first time.
Right.
If he didn't make a defense the first time, what defense is he gonna have the second time?
This line confirms to me that this person absolutely believes that the order has already been vacated, which is completely wrong. And again, we are at that point where you've missed the point from go.
Yeah.
Like, just straight up. That's what's happened here.
And that will make this effort 10 times harder. I mean, yeah, it probably would be more difficult to prove the case if Kyle had a case to put against it, but he doesn't, as he demonstrated by not making a case. And probably much more expensive than before when the default was one. Why would that change the price of filing again?
Well, no, what he means is, like, if the case goes on longer, that means there's a little more legal and attorney fees, which is correct to some extent. Right. But if I understand it correctly, because Steve has shown fraud happen, they can get is it treble damages for that, or the attorney fees at some point? There's a way to get attorney fees in this, I think. I've heard. I don't know.
And on top of that, you're still running into the issue that Steve would be suing the firm for malpractice.
If they had done something wrong and didn't fix it and didn't notify it.
Right, exactly. And the court case can still continue from the point where it actually is. There wouldn't have to be a refiling because Kyle's been responding.
Yeah, exactly.
So it wouldn't matter either way.
Nope.
Then they responded, Mr. Wheezy, this poor man, or woman, I don't know. Mandalorian had said, an actual lawyer versus a moron on the internet with no law experience. Yeah, I'm gonna take door number 1 with a lawyer. Mr. Wheezy responded to the Mandalorian. He is an appellate court lawyer. They don't do these kinds of cases. How about instead of reading his comment, their comment, how about you actually explain to us what it is that you do, so that way there is no confusion.
So, I mean, I formerly was an appellate attorney, yes. Mostly kind of the criminal defense, but I did do like 1 or 2 civil defense appellate cases and whatnot, and I did do 1 civil trial, which I won. But regardless, the thing of it is, as an appellate attorney, I know how to research and interpret and read statutes, which is all I was doing with this pleading online. The filings online. I was reading it and giving my opinion as to the legal water of the arguments Kyle was making and just laughing at them because that's what it was. Shockingly.
So what you're telling me is you're not Steve's lawyer.
Well, yes, number 1, I'm definitely not Steve's lawyer. Number 2, outright admitting not licensed in North Carolina. However, because I am, in fact, an attorney in general, I understand a lot of this stuff more than a lot of people do.
Right.
I'm not saying I understand all of this better than anyone else. I'm not any other attorney, whatnot. I'm not saying I'd be a great attorney in this case. I didn't do a lot of civil work, so no, I wouldn't have taken this case in the first place, especially something business law related. But I now work as a judicial staff attorney. I have touched a ton more civil cases than I did in practice. In these last 2 years, I have learned so much more about civil stuff. If I ever went back to private practice, I might actually be a civil attorney.
Fair enough.
So, shockingly, I do know a lot about how civil rules work.
It's almost like we don't pull on random people who comment randomly on YouTubes and actually verify a little bit about who we're talking to when we pull on a guest. Weird.
Right. Yeah.
So Mr. Owizi and Soapy-kun decided to make a bet, and now this is drama to me, and I'm following this drama, because Soapy-kun's like, all this rambling for nothing, we'll see if the case is lost. If it is, I will apologize in this thread, and if it isn't, I expect you to do the same. Alright, Mr. Owizi, we'll be waiting to hear from you. Because he accepted the bet.
Right.
How long will it be until Kyle blames his mom? He already is. He's saying he wasn't served properly, and his mom's the one who signed off on it. So if his mom signed off on it, then and he's saying that the service wasn't proper, he's essentially saying that his mom never gave him his mail.
Right.
Yeah. After reading the court docket, this is Lady Skeptic. After reading the court dockets and seeing Kyle's response to the court, Kyle kind of did give Steve a reverse card. The court has to take any and all evidence presented seriously. Kyle can file for a stay on the default judgment. I've had to do it before.
Yeah.
Has to take any and all evidence presented. Kyle did not present any evidence that he was not properly served.
Yeah, he just stated it. I think he used his own affidavit, which, okay, that's great and all. Self-serving affidavits are very looked at as very much so not worth a lot all the time, not nothing, but I don't
with a very large grain of salt.
Yeah, I don't remember seeing any actual evidence that Kyle's wasn't served properly. It has been over a month since I've looked at that monstrosity of emotion, so I don't remember everything that was attached to it, but I don't recall seeing anything that made me think, oh yeah, that there you go, that shows he wasn't served.
Well, I mean, quite frankly, would he not? I feel like if there was a piece of evidence, we would have discussed it, and at no point have we discussed anything because there isn't anything to discuss.
I feel like if there was evidence that he wasn't served properly, this would have been this default judgment would have been vacated months ago, and we would just be in the middle of the lawsuit.
Right. So here we get a little bit better of an idea of what Lulu63 is saying, because they're back. I don't know this lawyer, but at 9:53, he gets one of the most important and undisputed facts pertaining to the filing just wrong. Kyle moved out on July 15th. The summons of complaint was served to and signed by his mom on August 30th.
Yeah, yes? So I actually correct that later in the video, because I straight up admitted I misread one of the things on that Kyle's motion and whatnot. And I did at one point say that it looks like he moved out on July 15th. I fixed that later in this video, and I thought I even responded to Lulu 63 about that because I saw that comment.
Oh yeah, you show up in this thread of 101 replies.
Oh my gosh. I just feel like, I corrected that earlier. Because it's a people make mistakes. I made a mistake. It happens. Guess what? It happens when you're trying to speed read through something that you know is just, Oh, there I am.
Yep. And then this Lulu person is upset that they're saying that Reds used to be better than this. Used to be better than what, dick jokes? I'm gonna go ahead and throw a contention out there on that one. Check out the supplementary service, kind of important. And then this Globe Agent Wrong Burgundy. I'm a layman, so no experience in finding statutes, but I tend to search with supplementary service on the new North Carolina website containing their statute and couldn't find anything relevant. Can you post the number of the statute? If you look at the case, Fender versus Deaton trial court. Bitch, you already said I'm a layman.
Yeah.
I feel like... What? Kyle's mom did not live with him, work with him, and certainly was not his legal agent. Over 18 of legal age is the only requirement. The fact that it's his mom is just a little bit better. It doesn't really matter. It's just a little bit hilarious.
Right. Hold on a second. Fenton versus Dent. Like, again, the worst thing is most of these people never actually put, like, a citation in anything.
Right.
Go ahead and go on. If I find
I'm not saying I know that the default judgment will be default judgment set aside, but everything I've seen so far seems to imply he has a good chance of it if his paperwork is technically in order. I think some of his paperwork papers were not notarized, so that would be a problem for him unless he updates those, ? I have no clue what the lawyer on the stream is saying. There are countless of examples on default judgments being set aside, so something he claims is impossible for some reason has happened before countless times.
I don't know what
This person doesn't
no
know what
idea
they're saying, and they're saying they don't understand you because they're a layman. They don't know, so they're kind of asking leading questions. Their questions aren't, I don't think, are honest questions, quite frankly. Because usually when you don't understand something, you don't make this kind of a post. You're not sitting here, appeals court only reversed because the person signing was deemed as a legal agent for the plaintiff because she was his wife, lived with him, worked with him, signed regularly for his certified mail. Are you suggesting that he didn't live with his mom? If he was working on non sequitur while he was living with his mother, then he worked with her too, arguably. That's a bit of a semantic argument. That's just me being a wiener, but...
So, what this person's doing is taking a case in which the appellate court found that service was proper, because in this case, it appears that the trial court had found service to be improper, and the plaintiff appealed. The appellate court reversed, saying that service was proper. What this guy is doing is saying, well, this case had all of these things in it, and Steve doesn't have all these things, so it's not proper service. That's not how that works.
So he's, what a sneaky little bitch. Mm-hmm. So, okay. He's using that as a standard to say that you have to have these things because this was successful, instead of looking at the ones that were thrown out, which is the ones you would have to look at to actually make that judgment.
Yeah, at least I think that's what he's trying, because it's the only thing I can think of.
I've copied and pasted the relevant parts in my opinion. All parts say address or addressee. It is clear it must be delivered to the defendant's proper address as far as I can see. So this is this person going back and referencing that they screwed up number 4 and number 5. So we've already kind of addressed why Lulu63 is completely fucking incorrect about this.
Right, yeah.
Proof of service shall be as follows. ... Signed by the person who received the mail or delivery. If not, the addressees raise a presumption that the person who received the mail or the delivery and signed the receipt was an agent of the addressees authorized by appointment or by law to be served or to accept service of process, or was the person of suitable age and discretion residing in the addressee's dwelling, house, or usual place of abode. Wow, their last statement completely makes the goddamn point of why it was proper service. A person of suitable age and discretion residing in the addressee's dwelling, house, or usual place of abode.
Yeah.
Can we write off this Lulu63 person as a dumbass and not address any more of their arguments, because this is a dense motherfucker right here.
Yeah.
Hold on. Globe Agent Rog Burgundy at Lulu63. Yes, I agree exactly. There must be other issues I'm missing.
No.
I love it when the idiots group together. But at the moment it seems if Kyle can properly notarize and file all of his paperwork, he is the one with the stronger legal argument. The layman is going to decide what the stronger legal argument's going to be.
Good luck on that one, though. there is actual impartial NC lawyers saying so. Okay, where is this at? I'd love to hear this.
Yeah, who? Where? Link, please. I would love to have them on for a discussion. That'd be great. I'm sure it can go either way, though. But claiming Kyle has no fair chance with his motion seems very dishonest. It's not a fair chance. He just has no chance.
It's an extreme long shot. As I said there, and I'll say again, do I know what's going to happen? No, because courts and judges and law sometimes are weird and make strange things happen and whatnot. But In my mind, for Kyle to win this motion, something miraculous would have to happen, and I just don't see that happening.
We got a decent comment from Mike in here as well. It says, I noticed the wording usual place of abode. It doesn't say current place of abode, so saying an old address is irrelevant unless it was unusual.
Yep.
Correct. And Boole says, oh, it will be absolutely fair. It won't work out. It won't work, and that's fucking fair. And Boole messed up the at.
Yeah, like, exactly. Like, the court will give this its due diligence and its due consideration, and then do what it's gonna do with it.
Oh my god, and this poor Dat High guys. Best example given to Globe Agent Rob Burgundy. Oh. And then they complain that says, let's see how long this comment stays around. Well, I mean, it's been 2 months, so...
Yeah.
At least 2 months. Person K. Oh, I know, I was wondering about that, and that they didn't bother to correct it, and Reds knows it. Yeah, actually, I corrected that later. Good on you for watching the entire thing, though. Or not. Smiley face.
Yeah.
So that bitch is smiley face. Bitch just loves smiley face. Oh my god, you mad lad. I'm a layman. That pretty much is where you should have stopped.
Yeah.
You're a savage.
I mean, it's just when somebody tries to tell me the status of the law and then immediately says, oh, but I'm a layman, like, yes, great. You should have probably stopped there and not have made a fool of yourself for the rest of what you just...
Yeah, this is some dumb. Do you want to pull Steve in? Steve is like, let me in.
I've got to go in like 5 minutes anyway.
Okay, cool. So why don't we'll leave it there. We only got through one. This one comment thread has fucking 101 replies on it.
Yeah.
My god. So there's that. So there's definitely more we can touch on here. Most people are like, can you name a lawyer? Can you name a lawyer? What are you talking about?
Yeah, I like, he says it like it's a fact. Like, okay, cool. Tell me some North Carolina because if they're North Carolina lawyer, actual North Carolina lawyers are saying Steve's wrong here. Great. Why wouldn't they take up Kyle's case?
Can we please make a point here real quick that we've got Lulu63, we've got Globe Agent Rob Burgundy, Parson K, and what the fuck was that other person that we kept having? Let me scroll up here, hold on. Where did it go? 312. What the fuck? Fuck, I don't want to say his name wrong. Oh, Fortunate Son. Let's not forget about... Oh, and Mr. Wheezy, 312. So, keep in mind, guys, if you see... If you see, these names around, you kind of know they're full of shit. Like, right out the gate. And I'm gonna add Steve for 1 second, so give me a sec.
Sure, go
ahead. Let me add Steve. Why are you not letting me add Steve? Let me add Steve. Here we go. Oh, you have to accept my friend request first, lawyer. Mr. Lawyer. I can't add Steve without having both of you as friends. We weren't friends! Oh no! See, there you go. Confirmed. We weren't friends. He's not biased towards me. See? What'd I tell you? I'm gonna make sure my thing hasn't messed up. Okay, good. Fantastic. It has not. We cannot into Discord. I feel like Steve is gonna yell as soon as he gets in. Like, that's the first thing. Alright, here we go. Hello?
Hola! Hey, can you hear me?
Hey!
Hey, so our visuals is gonna be a little bit messed up for a second while I get everything switched. Which I'm probably gonna be... You guys probably won't actually be able to see me now, because it's showing all of Discord, and it really shouldn't be, but it is, because that's the way it works, because Discord is kind of a giant pain in the butt sometimes. And I've lost.
Why I don't use it.
I've lost my button. Well, yeah, when you just decide to come in halfway through, but you're welcome that I let you in here.
It was 88 minutes in. That's more than half.
Yeah, whatever.
Yeah. Anyways,
we'll
OPT.
just move us to the bottom corner. There we go. We'll just move us down there.
Yeah, it's strange to think that OPT lawyer actually went to law school, right? I mean, wow, crazy.
Shocker, right?
It was straight up saying it was the hardest thing I ever did.
I have no doubt. But so let me ask a quick question before you take off, because I want the people to recognize this fact.
Sure.
My lawyers, well, one now because it was two, but one left obviously to go do something else. But they have a duty to inform me if something is catastrophically wrong with the case. If there's a material breach of some kind that they screwed up, they have a duty and onus to inform me of that.
Yeah.
They have not, by any stretch of imagination. Matter of fact, quite the opposite, right?
Yeah.
And my lawyer has absolutely assured Kyle has the onus to demonstrate that there was some kind of malfeasance or improper. He calls it was called gross. What the hell is it? What's the legal term? Gross something or other. Not negligence, but it's.
I'm trying to think what that word would be because there's so many things that start with the word gross.
But it's anyways. He has to actually show that he was not informed of the case. He had no knowledge of the case, that he could not respond for some reason, that he did because he didn't know about the case. That's going to be a very hard thing to do when he's already responded, and he has filed motions. Right?
Yeah.
I mean, so
the funniest thing to me in this whole thing is the fact that he first filed his response to the judge's default order, and then files his motion saying I didn't get proper.
That was kind of odd, but that's okay.
Yeah.
But you agree that my lawyer would have to tell me if there was a problem with
It's
service.
stupid.
Well, if your lawyer screwed something up, even if they fix it, I believe anyway. Again, I don't know what North Carolina's ethics rules are, but I mean, I would assume you would be responsible to at least tell your client, "Hey, we screwed up. Now we can fix it this way or this way or this way, but you should know we screwed up because you might have some action against us." Now, if they can fix it and there's no damage, there's nothing to sue over. You might just be determined, well, that's great of you to fix it, but I don't feel like having you around anymore because you screwed up, so I'm going to go find somewhere else. As the client, you have the absolute right to fire your attorney at any point during the entire proceedings.
Makes sense.
Right.
With certain limitations.
Yeah. So, I mean, Kyle has to actually give a legal reason why he wasn't served properly. He did not give a legal reason. He gave unsupported hearsay testimony, has no relevancy to anything.
He gave
because
no
it's just completely irrelevant. It's just it's like saying, "Hey, I wasn't served," like somebody said, because I didn't open my mail. That's not an excuse.
Right. Yeah. No. It's the burden of proof is on Kyle to show that he did not receive proper service. It's on him now because service has been accepted as proper by the court.
Correct.
Now he has to show that it wasn't proper, which in his motion, I'm just going to give my personal opinion that is kind of light on the subject of improper service, but that's...
I would go so far to say not only light, it's just practically stupid. I mean,
yeah.
Because I didn't serve him, my lawyer did, and it was to the business address. That's all that matters. Somebody signed for it. There's no legal standing that he had. He didn't give any statute for it.
I can't exactly be more explicit about this. The court has accepted it as proper service, which means that the burden of proof is on Kyle. This is not an internet argument, nor is it a formal debate. This is not how this works. If you are conflating these two things and or confusing them after watching this shit, you're a goddamn fucking idiot. You are an absolute moron, nincompoop, asshole. Dear God, stop making yourself look like such a fucking moron.
In North Carolina, service is presumed upon mailing. So they have to have a rebuttal to that. There's been no rebuttal of process. That was explicitly in that what we filed with the court. There's been no rebuttal so far.
Yeah. And I also know that OPT lawyer has to go. We've kept him a little bit long, and I just have this one thing that I want to go out on. So last word from OPT lawyer. Last word from Steve, you go first. Then OPT lawyer can go, and then I would just want to play this clip real quick for everybody.
Sure. So everything OPT's lawyer has said is consistent right down the line with what my lawyers have said. So when I've got two lawyers that are saying the exact same, well, technically three because my first attorney, who am I best to listen to? My actual attorneys are being paid for this, or these internet e-lawyers that clearly have no fucking idea what the hell they're talking about. From step one, they were fractally wrong. Everything we've been saying has been correct. If people want to listen to them, I don't care. Believe who you want to believe. That's your choice. That's a God-given right to believe whatever the hell you want. I don't care. But when you say things that are false, that are material facts of the matter, like, oh, Steve hasn't really won this because it's just a default judgment. That's bullshit, because what is in effect right now? The partial default judgment. And the only reason there's partial default judgment is, as OPT lawyer astutely pointed out, is because we're looking for damages only because Kyle has not given us proper financials. That's it. So
learn how to read.
I don't care, but everybody all these comments, every one of them is, you can demonstrate that they're wrong. They clearly have no idea what they're talking about.
OPT?
There you go.
Go for it. What do you got for us?
Oh, just basically, comments like these just frustrate me because, one, they're just spreading misinformation about how the system works, and two, they for some odd reason have conflated or confused their Google search with my law degree.
I like that. Can we quote that? You've conflated your Google search with my law degree.
It should just say degree, so it's more useful to more people.
Well, yeah, there's actually like mugs and shirts with that saying on it. And the last part is like blank. It is like fill in the blank degree or whatever. Yeah. So yeah,
I love that though.
Yeah, I deal with this as a practicing attorney. I deal with this on social media all the time. So honestly, none of this is surprising to me. It's just that people just don't either they are completely misunderstanding what's going on, or they're just doing it on purpose because they don't like Steve, or they really support Kyle for reasons I'm not entirely certain of. But whatever. Good job. Congrats. You like someone over someone else. Okay, great. I'm not going to tell you who to like. I ain't going to tell you who not to like. But when facts are in play, they are actual facts. Things have happened. They are factual. They are done. They are what Doctor Who would call fixed points in time, for crying out loud. What do I know what's going to happen in the future? No. Do I have an opinion on what's going to happen in the future? Yes, absolutely. But I'm not Steve's attorney. I'm not even licensed in North Carolina. So all I can sit here and do is look at the public pleadings and just kind of chuckle at some of them, which is what Reds and I were doing in the two streams. The other one we didn't get to right yet. But
so if you were a betting man, you had $100. Who would you bet on? The judge siding with Kyle and I lose everything, or just the opposite? I mean,
that'd be you. If I were.
Oh wait, you're not an idiot. I forgot. I wanted to ask you that.
Yeah. Let me specify here. Nothing in this stream counts as legal advice. Get yourself a lawyer's worth of damn if you need legal assistance.
Please, absolutely.
Yeah. Hire a lawyer. I don't even OPT lawyer isn't even legal advice from him. He's just saying shit.
Yeah,
I'm not taking any of it as legal advice because that was stupid.
No, my goal at any time I do anything like this is just to educate people on what terms mean, what certain things mean, and then if you've got a bigger question because you have a case, go talk to an actual attorney and just say, all I want to do is educate people on the system itself, because so many people are confused on our justice system, on our judicial system. They don't understand a lot of it, and that's fine because most people don't even come into the system. I understand that. That's why I like to help where I can, and sometimes that's just really, really, really frustrating.
It's weird that the people would think that somehow like these e-lawyers would have a better understanding than Chester and I, because I think Chester and I have demonstrated we at least have a tertiary understanding of these things. I did take a little law. I happen to like the topic. I was pretty good at it. But we actually are not idiots.
I don't know shit about shit. I'm just not a moron.
Vibrantly Brantley. You're just not an idiot. So that's fair. More than what. By the way, that's way more than people that left these comments.
It's really not that difficult to follow along. Vibrantly Brantley, especially with how often and how differently in different ways we've spent explaining it. So it's not like you have to take our word, but you can kind of sort out what the fuck's going on for yourself just by having people talk about it who aren't idiots. Vibrantly Brantley for $5 says $5 that Kyle wins, paying in advance.
Fair bet. Thank you,
Well,
Viper.
thank you. So we're just gonna wrap it up here, and I just want to. I'll be hanging up on you guys, but that's just to get you guys out the hell out of my way. And I just want to play this last bit for everybody because realistically, this is the best part. So with that, we'll see you guys next time. Bye now.
Cheers.
Oh, I had to. What I did was, I in the original papers that I was served. 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 Papers that I was served.